Hi, I'm Nora Baba. I'll be talking about the legal issues in kinesiology physical therapy edition. This class is called Legal Aspects of Kinesiology. I'll go ahead and start. So my faculty background would be the physical therapy clinic. Why I chose physical therapy is because I chose this because of exploring and research legal issues in physical therapy clinics. The physical therapy career is the career path that I choose to go into. So after completing my master program, I therefore will be exploring the potential legal issues related to risk management, employment, and liability in the physical therapy clinic. In the practice of being a physical therapist, it includes using physical therapy intervention to promote and maintain physical fitness in order to improve people's health and well-being and associated to their ability to move their bodies. The potential legal issues related are those. I'll be talking about the risk management, employment, and liability in the physical therapy. So starting off with risk management. So I observed working along with physical therapists in the areas of low back, neck, shoulders, hands, wrists, and of the body regions that the physical therapist is more likely to hurt while working with the potential patients. So starting off with Bennett and Elizabeth Health System. A background with that is this case study was when the worker was trying to help a patient out of the chair at the office. She got hurt. The physical therapy was providing at the hospital for the patient after surgery. The worker claimed that the physical therapy was given in a negligent manner, causing further damage to her left shoulder. The physical therapist was undergoing rehabilitation for her original work-related admitted at the time. She reportedly re-injured her left shoulder. The consequences and injury that occurred to the physical therapist's left shoulder is related to her job, since she would not have sought physical therapy for the shoulder. It has been for the initial eligibility of compensation injury to that shoulder. So as a result, it qualified as a covered injury under the Workers' Compensation Act. The verdict was upheld. So the proper techniques of so a way that this could help when I was looking at this case study and ways to improve would be the proper technique of transferring patients and prevent injuries, helping to physical therapists or client. A patient's head should move away from the hips when being transferred, and movement and removing any barriers during that transfer will both benefit from this. The second case study was Pavert versus St. Timothy Parish Hospital. In this case, the patient was using both railings and was assisted with a gait belt, and a contact guard helped to climb and descend 8 steps. She was standing on a solid surface after taking the final step. Patient turned to conduct an activity once again, but her therapist could see that she was having difficult turning. So according to the incident report, Pura was able to move her right lower extremity a little bit, but she was unable to move her left lower extremity. So according to the physical therapist, the patient reportedly declined the physical therapist's offers to help. When it comes to cases like this, when it comes to a physical therapist dealing with patients with gait training, it's important to make sure all equipment and areas are safe for you and the patient. In this case, the patient declined the physical therapist's help on assisting on going down the stairs and turning. However, the physical therapist should have adjusted their grip on the gait belt so the patient can have a safe fall and not re-injure any body parts again or cause any more further injuries. And lastly, the COVID and PMC physical therapy one. They sought for eligible medical misconduct and malpractice related losses. And the plaintiff claims that Dunn violated recognized medical practice by using excessive and extreme rotational stress throughout a neck multiplication that caused left vertical artery dissection and generated a several infraction of the left cervical. So what this case is that the plaintiff was laying on the table while the physical therapist was evaluating him, In this testimony, he said that after Dunn had massaged his neck, he had taken a hold of the plaintiff's head, dragged it upward and forward, and turned side to side. During that manner, the plaintiff's alleged experienced a significant discomfort in his neck and claimed that they're going to resume rubbing his neck after that. As someone that has experienced or has seen this in the physical therapy clinic, as a physical therapist, you should read everything carefully and observe the patient's pain levels throughout the evaluations or follow-ups. If there's something that the physical therapist is not comfortable in or does not have enough practice in, the physical therapist has to notify the patient themselves of the outcomes that are beyond the scope of their knowledge and experiences, or the point to need the care for the outside scope of their physical therapy. This must also keep proper documentation, and then this includes progress notes as well. So employment laws is, when it comes to employment laws, many topics come into play, such as discrimination, racism, and general equality. The first case study I'll be talking about is Cummings versus Premier Rehab Keller. In this case, it's Jane, a person who is deaf and legally blind, and requested rehab services from this rehab center, Keller, and asked the company to arrange for an interpreter who can communicate with her in American Sign Language. But the rehab declined, advising Cummings that the therapist may get in touch with her in another way. Cummings sued the rehab, claiming the company failure to provide an American Sign Language interpreter amount to disability discrimination in violation of both the Rehabilitation Act of 1973 and the Affordable Care Act, that Cummings was seeking damages and other remedy. In this type of case, I would have tried to prevent this from happening if I was the owner or the physical therapist themselves, by getting a patient's medical history prior to scheduling the appointment and requesting the ACL interpreter. This will help me as a therapist and help the patient who's seeking rehab to get the proper care they need from the therapist and from the rehab center themselves. Not only would this be for legally blind and deaf patients, but as well as non-speaking English language patients who do not have the access of family members who can help. That's a major proper one that people need to go through. The second one is I might be pronouncing this wrong, so bear with me. Gularam versus CMTV Physical Therapy and Associates. The plaintiff claims that the CPT failed to pay her and other people in similar situations for all of their deserved overtime composition. So according to the Fair Labor Standards Act, the plaintiff requested step 1 certification of a collection action. So the plaintiff claims that because of the physical therapy company themselves production exceptions, the therapist and therapy assistants worked after hours to finish their works. She indicated in her testimony that all 3 regional supervisors have received reports stating that the numerous therapists and therapy aides have claimed to be working off the clock. And so in terms of these, I would try my best as a therapist to finish my work during my time period, and anything after that, I would have to talk to my boss or the boss above my boss, which is HR, to see if they have any composition for overtime. As the law presents itself, the employer is required to pay the employee for overtime pay if the employer gives instructions to the employee to stay over or work on charts or other job duties. So this is only going to help if I, as a boss, say to the employer, hey, it's okay for you to work overtime. Yes, you'll be credited and get paid overtime for that. But if the employer goes out of their way to go into overtime without my approval, then that's a situation where we will have to talk about it, but that will resolve throughout the day. Lastly, it will be the Kelly Clocks versus the OASIS Physical Therapy Clinic. So Mrs. Cox filed a lawsuit against the physical therapy place, and it was towards Mrs. Irvine and Mr. Zendaya for several reasons, including sex and gender discrimination. And then this would also include into their case study the hostile work conditions and unequal treatment and disparate impaired under the WLAD, negligence in hiring and keeping and supervising employees, and the deliverance of wrongful inflammation of psychological distress, this outrage and battering and assault. So when Ms. Cox reported Mr. Cerzea widespread sexual harassment and abuse during her employment, they allegedly threatened and intimidated her, and general sexual orientation and hostile work condition, environment, discrimination and violence of the WLAD, negligence in hiring, retraining and supervising employees, and deliberate or negligence or general gender discrimination. When it comes to general discrimination and hostile work conditions and unequal treatment, as a therapist or manager should have working conditions fun and not hostile, as well as accepting everyone's no matter what their gender or race is. In this career, dealing with different races and gender can become challenging at times because people will put a stigma on things, and that shouldn't be talked about. Therefore, professional therapists, we are taught to steer away from those situations and become respectful and not judge the patient / co-workers as we're working. This gender discrimination is huge in a field of the medical field, and also working conditions are very a high topic in this situation, because you're dealing with a male physical therapist and female physical therapists. So things like that there's a fine line. But as a manager or a person that wants to go into a career like that, knowing the facts that these are mainly issues and ways to resolve this can help me stop this from happening in a career that I may be going into. So application and the faith. So I've learned the challenges of physical therapy have faced and the consequences that are held upon the medical professions if they choose to go against them. So things I would look out for to make sure I'm providing the proper care is the number one thing for me as becoming a physical therapist, and making sure that if a person has a language barrier to request an interpreter before the appointment, and then as well as a physical therapist, making sure all equipment in the facility is up to date and is up to code with every potential patient that may be coming into that clinic, and can withhold the body weight just in case the situations like I've mentioned in this presentation do not happen, as well as dealing with general discrimination and hostile working styles. Those are ways I can kind of, knowing that those are a thing in the real world, and I'm dealing with that in a clinic that I'm working at, is very big, and I now understand what to do for that. So with that being said, 3 biblical verses that I've kind of reached out to me is Matthew 7:12, which is, "So what you wish that others would do to you, do to also to them, for this is the law and the prophets." So what we must do to people in advance of their doing good to us, therefore trusting in our Lord that He will reward us later. In which if you wish for people to give you the respect and trust, therefore you have to show them the same. And I 100% believe that in the medical field is that if you go about respecting and trusting and showing that you are there for them, you will get that in return, and God will reward you at the end, no matter what it is. It might be 5 years from now, to a couple minutes from then, but God will see that, hey, you are putting forth your love and ability into these people to get them better. Next is Romans 4:4, which is not to the ones who works, this wages are not accounted as a gift, but as his due. So this goes along for the employment laws. If you're a hard worker and you do a good job, you deserve your pay. We don't call your wages a gift. In other words, the amount of energy and dedication you put into your work should show through the wages your employer gives you and should be presented as a reward rather than a gift. So these salaries and wages that we're getting as employers should not be something an employer should be giving you as a gift, but as a reward for your hard work and dedication and getting those patients back to how they normally are. Lastly is Proverbs 10:9, in which it says, "Whoever walks in integrity walks securely, but he who makes his ways crooked will find out." This was another one that reached out to me, that kind of pointed out to me, was the reason why integrity is wise, according to this passage, is because it leads to security. So when walking with integrity, you walk with confidence and with honor, and you will show a patient and coworkers that they can trust you and they can put that they can have that respect for you, because you're showing them that you are worthy and ability to accomplish things in life and accomplish what is coming towards you. I appreciate everything that I've learned in this course, and I thank you so much, and hopefully I see you guys soon.